Hello and welcome to Insight. I'm Kusum Wijetilleke. My guest today is Dr. Gehan Gunatilleke, a commissioner for the Human Rights Council of Sri Lanka. Dr. Gehan, thank you for being here. And you're also the first returning guest on Insight. So thanks again for the double appearance.
Yeah, thank you for having me.
So Dr. Gehan, you've been a commissioner of the Human Rights Commission of Sri Lanka since June 2023. Human rights seems to be a regular topic of discussion in Sri Lanka from various things, from the pogroms, 70s, 80s insurrection, separatism, police brutality, and forced disappearances. More recently, the Yuktiya drug enforcement program. Can you tell us, I mean, even this government, just this 1.5 years, the High Security Zone Act, the Anti-Terrorism Act, which you came the last time around to discuss the Anti-Terrorism Act. What's the state of human rights in Sri Lanka overall? I mean, we seem to have a lot of very old institutions, laws, customs. But there's always so many deficits that we come to see day-to-day life when it comes to rights and, I guess, justice and accountability. What's the deal with Sri Lanka's human rights situation?
So I think, so first of all, thank you for having me on the show. I think you mentioned institutions. And if I were to distill Sri Lanka's challenge in terms of human rights, I think it's fundamentally an institutional challenge. So all the laws you mentioned, yes, some of those laws are very problematic. They are overbroad and they can set the stage for violations of human rights. But you also have laws that are actually model laws that are actually modeled on the international human rights standard. A classic example would be the International Covenant on Civil and Political Rights Act of 2007. That law is more or less word for word a replication of the International Covenant on Civil and Political Rights. So here you have the law really reflecting the best practice or best standard out there. But then look at Section 3 of the Act, which prohibits incitement to violence against a particular community. Look at the amount of inconsistencies and abuse in terms of how it has been implemented. And that is a classic example of a problem that is not down to just the text of the law, because the text of the law doesn't seem to have a serious problem. It's down to the institutional enforcement of the law. Right. So I think if we were to really think about Sri Lanka's human rights situation and the challenge that is faced in terms of human rights, it really is an institutional challenge. And reforming institutions has to be the number one priority as far as human rights is concerned in the country.
So on the online safety, before we get to the specifics of the online safety bill, I just want to break down some of the core issues as I see them. So regardless of the medium of communication, and generally speaking, I may be a bit of a devil's advocate here, but society generally should attempt to reduce the spread of misinformation and falsehoods. I think we can both agree on that. So there are laws as it is that restrict what you can print in a newspaper, what you can air on a television program, etc. So we have laws against defamation, libel, that sort of thing. So then the problem around social media revolves around the publishing issue and whether we treat the platform as a publisher. And then the other problem is that that this information is disseminated very fast. But I assume that everyone has a right to an opinion. And if they have a social media account, they have the right to express that opinion. And also, they have the opportunity to have that opinion heard by those who follow them. So in this, based on those sort of wide barometers of what is the online safety bill, this specific OSB version trying to achieve that you see? Or as a commissioner of the Human Rights Commission, how do you view that?
Yeah, so you mentioned something interesting in that question about the fact that laws are in existence already to allow people to respond to and contest things that are defamatory. Right? Now, let's take that as an example. The law that actually exists is not criminal law. Okay. You don't involve the state and the police as an institutional actor in ensuring that X doesn't defame Y. Instead, you have a civil remedy. So if a newspaper defames a person, that person can take the newspaper to court, file a case, prove their case before a court of law, and then get damages if that person wins. you don't involve the police in a criminal investigation. No one is at risk of going to jail and facing incarceration. And I think that's an infinitely better way of dealing with speech-related challenges. Because after all, as you mentioned, everyone has the right to the freedom of expression and opinion. Sometimes you get that exercise wrong, and people should have a remedy against you. But it's best that that remedy sits in the civil law domain, where a court of law can determine the outcome of a particular case and a claim.
Okay.
Leaving that remedy within the domain of the criminal law and necessarily the police is dangerous because, as I said before, we first need to reform our institutions to ensure that laws are actually enforced in good faith and not in an overbroad or excessive manner. Going back to the ICCPR Act, we've had 17 years of this act. And I don't think there's been a single successful prosecution and conviction of someone who's actually incited violence against a minority community. Although we've had that occur in Sri Lanka on repeated occasions, right? We've not actually had that. So the purpose of the law has not been served. Whereas you've had numerous occasions on which persons who are accused of blasphemy, of offending a particular religion, have been arrested under the law, only to be released subsequently when people realize that you can't use this particular law to criminalize blasphemy. And in fact, the Supreme Court recently, in a landmark judgment, said that this law is not a blasphemy law. Right. It was in the Ramzi Razid case.
Yes.
So really, my answer to your question is, there should be remedies. There must be remedies for speech-related challenges. But these remedies must not be dependent on law enforcement getting involved, because we have a serious institutional problem in the country where laws are applied in bad faith.
Right.
And until we resolve that problem, we should be confining our remedies to the civil domain. And even say we do reform our institutions, there's a bigger question mark as to whether people should be put in jail for the things they say. And if I were to say concretely what should result in criminal liability, it should only be in instances where you are inciting others to commit violence. If your speech is actually inciting physical harm to other people, I think then you might be able to argue that that deserves criminal liability. For everything else, there are alternative remedies in the civil domain or in the regulatory space that are much better. So if, for example, a broadcasting authority or a broadcasting company issues statements that are defamatory or issues statements that are false, maybe their license should be reviewed. But no one should be going to jail for it, because jail time is an extreme measure, extreme penalty that is often disproportionate in terms of the actual harm that speech will cause. Which is why I go back to the point, incitement to violence is the one thing that we do need criminal remedies for, criminal law remedies for, which unfortunately we don't see enforced in the country.
Okay. There's been a lot of conversation about the OSB and how it sort of compares to the Singapore, it's called the Singapore Protection from Online Falsehoods and Manipulation Act 2019. Now, some of the, I think Learn Asia had put out a statement last year that many provisions of the new bill appear to be modeled on Singapore's POFMA. However, there are significant differences, and you mentioned the religious aspect. So, unlike in the Singapore Act, the Sri Lankan bill includes a subset of offences which are related to religion. For example, disturbing a religious assembly by a false statement, Section 15, and communicating a false statement with deliberate intent to wound religious feelings. So this sort of brings us back to, and you mentioned the bad faith application of these laws. So you mentioned Razmi Razik, and there was the comedian Natasha Edrisuriya, there was Arnav Jazim, who was the poet from the post-Easter attack case. What do these 2 or 3 arrests, for example, and we can mention Hejaz's Bull as well, specifically if it refers to this, but what does that tell you about this, what you mentioned, the bad faith application of this law? Is there some, so if they're not specific, and for example, in the OSB, who has the power to determine whether someone's safety, online safety has been attacked or put at
Okay.
risk. So what is the
Yeah.
institution that's in charge of this? Because the way I see it, what we're essentially saying is someone has to someone has to be the arbiter of the truth.
Yeah.
Or you have
Yeah.
to say, this is not false, this is true.
Yeah.
How are we going about this in Sri Lanka? It's a very complicated thing.
Yeah. So you asked about the purpose of the law, and I got carried away answering
No, sure,
part
sure.
of the question, but I didn't answer
Sure.
that question. Let's go to the purpose of the law. So the law is termed online safety.
Okay.
So let's assume, to begin with, the overall purpose of the law is to advance or promote online spaces as safe spaces.
Okay.
Now, let's look at how the Supreme Court views this law in its determination. And there are some passages that are actually very, very important in the Supreme Court determination. The Supreme Court kind of raises the question, well, this is about online safety, but it doesn't seem like certain phenomena that might be associated with the lack of safety, like phishing scams, like cyber attacks, like, if I were to expand that list, things like malware, spyware, denial of service attacks. None of these things are featured in the bill. None of these features. So then immediately you have the question, is this really about online safety? Instead, what the bill actually does is replicate a bunch of Victorian penal code offenses that we've had in our penal code since 1880s, and adds certain language into that, like false statement, online space, and sort of tweaks these offenses, and now says these are the offenses that are covered in the bill. So really, it's not advancing online safety, and the Supreme Court is absolutely right to point that out. And you mentioned wounding religious feelings. That's an old offense that's in the penal code. What they've done is they've replicated it almost word for word and added certain elements like, wounding religious feelings through a false statement and wounding religious feelings through a false statement in an online space, right? I mean, the original offense in the penal code is broad enough to capture both false statements and online spaces. You don't need to actually include it in a new law, right? It's already a very broadly worded law. And in fact, people are arrested and charged under that penal code offense as we speak. So the question might be asked, what is this new law actually adding, right? Because people currently are prosecuted or charged under the ICCPR Act for online statements. They're charged and prosecuted under the Computer Crimes Act for online statements. And certainly the penal code, all these offenses are currently in use. So then the question is, what is actually the addition? What is the value proposition? So again, the Supreme Court makes a very important observation on this very clause that deals with wounding religious feelings, and asks the question, well, what does this have to do with online safety? And the act that is finally brought into operation through the Speaker's certification has somehow retained that offense without paying heed to the Supreme Court's determination that this particular inclusion is deeply problematic. And actually things like phishing, things like spyware, malware should have been what is included. So in a context where the Supreme Court makes this very apparent and makes its criticism very apparent, the Online Safety Act retaining these offenses, these Victorian-era penal code offenses, in sort of tweaked form, is deeply problematic.
Dr. Gehan, just for our audience's benefit, you're here representing the Human Rights Commission of Sri Lanka. But some of the questions I ask you may have to just
no, absolutely,
talk more generally.
Thank you for raising that.
Beyond your remit.
Yeah.
So I just wanted, you just mentioned this wounding religious feelings, which seems to be a big part of the OSB.
Yeah.
Where do you go from wounding someone's religious feelings to incitement? How do you connect the two?
That's a good question. So,
because I just wanted to clarify, if I'm personally hurt or upset by something someone says, I don't think I have legal recourse to anything.
Yeah.
Right? Unless I can show that I've been hurt or made some sort of income lost, or how does this,
so
and when, at what point do I then incite people? I mean, how does this?
So this is a great question. there is a vast difference between wounding someone's religious feelings or offending someone's religious sentiment and incitement.
Right.
Unfortunately, our law criminalizes both things. Our penal code was framed during a time when the British were absolutely preoccupied with public order. And they knew that communities are quite sensitive about religious sentiment. So they're not interested in developing sort of coexistence and creating harmony. What they do, they're interested in maintaining public order so the commercial enterprise of the colonial state can continue. So wounding religious feelings is criminalized.
Right.
Going into someone's religious space and desecrating their religious object is criminalized. So they approach this issue, this challenge, through a criminal law lens because they can't be bothered doing anything else. And the best way to manage these natives, quote unquote, is to criminalize their activity and then punish them if they fall out of line. Because they anticipated that if they don't, there'll be a lot of contestation, violence, conflict. And that was the case. There was quite a lot of conflict on religious lines during that period. We weren't the sort of model colony that sometimes people claim we were. There was a lot of contestation. Now, that kind of offense was never taken out of our statute books. They are retained even today. So if someone was to wound or outrage religious feelings, there is a possibility that person would be prosecuted under the penal code. But unfortunately, instead of being prosecuted purely under the penal code, they are prosecuted also or charged also under the ICCPR Act, Section 3 of the ICCPR Act, which deals with incitement. Now, that's a completely different ballgame. Incitement is where I say something to you to actually provoke you to attack another person on the basis of that person's national, racial, or religious identity. So that's a higher threshold. Just saying something that wounds that person's religious feelings doesn't meet the threshold of incitement. I actually have to gather other people and convince them that this other person is a danger or this person should be targeted. And I'm so influential that I'm able to actually incite violence or discrimination or hostility against that community. So just merely wounding someone's religious feelings or saying something offensive doesn't meet that threshold. What meets the threshold would be a statement, by a powerful political actor or religious actor telling his community or her community that this other community is bad news or they're alien or they're controlling, the market, and we need to attack them. We need to boycott their businesses. As if that hasn't happened in this country. Right. It has, but no one actually gets prosecuted for such statements. So it's really quite bizarre that we have this law on incitement that is both over-inclusive and under-inclusive. Over-inclusive because it includes things that have nothing to do with incitement, and under-inclusive because it seems to surgically exclude things that amount to incitement.
Right. So is there something we can do in terms of, is this a gatekeeping issue, kind of? Is it kind of the government trying, because in other countries, let's say in the US, for instance, social media has sort of become this liberal conservative issue where they feel that there's a liberal bias to information that is moderated on their platforms. On the other side, we've seen there's a competitor to Twitter in the United States called Truth Social, which is another very similar platform, which is has a conservative bend.
Right.
Are we seeing something like that where is there anything the OSB, for example, through the enforcement mechanism, or let's say the commission that's meant to judge what is safe and what is not? Is there some sort of a gatekeeping thing that you've or the commission, the Human Rights Commission, has seen?
So the Human Rights Commission statement on the online safety bill raises several issues, and one of the issues it raises is with respect to institutional reform and the need for reforming institutions because of the way existing laws are being implemented. But if I were to take my Human Rights Commission hat off and sort of comment more broadly on our media landscape, I think our mainstream media, and you would be better placed to sort of analyze this than me, but our mainstream media has been through many decades of repression in this country, right? And what happens with repression, and we've had various forms of repression also. We've had the more physical, straightforward repression that one associates with the 80s and the 90s, with even the 2000s, where journalists were assaulted, journalists were disappeared, murdered, news institutions and media houses were set on fire. We've gone through that history, right? And there's a legacy created out of that history where media institutions are survivalist. They need to survive in that space. And to survive in that space, there's often compromise in terms of how certain things are reported. And then there's a whole group of independent journalists that operate slightly outside that space that provide a more accurate picture of what is happening. And often these journalists and these activists, these civil society voices, don't use and can't use mainstream media, which is often a captured space. They need to rely on social media. And the fear here is that if you don't control social media, you can't control the narrative. And the online safety bill is often associated with that agenda to control the narrative. And I think that's what you were trying to get at, right?
Yes.
So there's this sense that in the lead up to many important political events, with the mainstream media, there is some level of cooperation that might be, extracted through pressure and through various means.
Right.
But when it comes to social media, it's such an unregulated, wild space. You need a new framework to bring it under control. And this is the framework that is being proposed here, right? And I'm saying proposed because it is such an ambitious task, right? A lot of the tech companies, the multinationals have said, you can't do what you claim you're trying to do under this law. It just does not, bode well, both in terms of our response, but also in terms of your technical ability to deliver such a vast, ambitious infrastructure to control the online space. And to answer your previous question, it's all going to boil down to this commission, the Online Safety Commission, that they're going to establish. That will be the arbiter of what is true and what is false.
And who appoints the commission?
It'll be the Constitutional Council. So one of the amendments that were brought in through the intervention of the Supreme Court was that the Constitutional Council will be the body that recommends appointments to the Online Safety Commission. And therefore, there would be assumed independence. But still, leaving aside the independence of the commission, you might have great commissioners on the commission. But the task is a vast and ambitious task where the commission would receive, a great number of vexatious and frivolous complaints from various people who don't like what they see on social media. And this commission will have to, separate those vexatious and frivolous complaints from the actual genuine complaints that deal with issues that require response. That's an enormous task. And then also the commission will need to decide what is a false statement and what is a true statement. And it's a very high threshold for what is false and what is true.
Isn't it?
How it's going to do that is anyone's guess. So I think this bill has not been thought through very carefully. And it's been rushed through. And many people, including the Human Rights Commission, urged the government not to rush through such a bill, because the intention to create a safer online space is actually a noble intention.
Sure.
It's a worthwhile pursuit, but doing it properly is very important. But when you do this kind of rushed legislative process, the chances of making mistakes are also much higher. And now people will be looking at this Online Safety Act that has been certified by the Speaker with a fine-tooth comb to see whether it has in fact complied with all the various observations and recommendations of the Supreme Court.
I mean, growing up, Gehan, it seemed to be like in the era of print, gossip existed. There were still things being written that you can't really clarify if it's true or not. So these were tabloids, essentially, right? So in a way, we've kind of ignored this. Tabloids still exist, at least abroad. It's even in Sri Lanka. There's plenty of tabloids. There's plenty of online internet websites that are essentially gossip sites, right?
Yeah.
What about those? I mean, it's just So we are saying online safety bill. That's not specific to social media, is it?
It is in the sense that social media and also online spaces are is the sort of main domain that this bill will deal with.
So will it attack gossip websites as well?
So offline content will not come within the scope of this bill.
Okay.
But anything, the online spaces or online location is defined very broadly. And it will include things like websites. It will include things like chat groups. I just had a glance at the act that was certified by the speaker. They've also included emails, SMSs, MMS within the scope of exceptions, but subject to further requirements to take down content within 6 months of the bill coming into operation. So that would mean that technically going forward, even one's emails will fall within the scope of this law. I think that has to be looked at very carefully because that certainly wasn't in the original bill and certainly wasn't the intention of the Supreme Court, because the Supreme Court's determination was very specific, very explicit, that email services need to be excluded completely from the bill, as opposed to excluded with this caveat that content needs to be taken down in 6 months. So that's a problematic element, and I think people will be studying that to see what the outcome of that process is.
Again, a more general question, Dr. Gehan, how do you define what is harmful speech, or is that it's harmful speech the same as hate speech? How do you, I mean, just online, it's hate speech is defined as discriminatory, biased, bigoted, or intolerant, or pejorative. So, I mean, is there something specific about harmful speech? Again, I guess this is kind of similar to the question about insulting someone's notions of whatever religion or whatever, versus whether they incite someone. So, what is the threshold for what can be considered harmful speech? I mean, it seems a little, again, it's very vague. So I guess it comes back to the same problem whereby you've given a very vague problem with very little specific rules and regulations to how to apply.
I think that's a great question, and the answer to that question is never going to be clear, because it boils down to usage, right? What we consider harmful will have objective elements in it and also subjective elements, and these types of definitions, terminology will evolve over time. Right? Very simply speaking, harmful speech is speech that causes some kind of harm. Then the immediate question is, what is harm? Right? Harm has to, it boils down to some negative consequence that people encounter as a result of
trauma
something.
come into this?
Yeah, it will be harmful, because harmful will also be subjective. The answer to the question shouldn't be getting a better definition for harmful speech. It's to ensure that we don't associate criminal law with harmful speech. Instead, we associate criminal law with a very specific subset of harmful speech, which is incitement. And then you need a very precise definition for incitement, which we have. The law does have a fairly good definition for incitement. So, and then there are guidelines that have been issued both globally and by the Human Rights Commission. Back in 2019, the Human Rights Commission issued guidelines on how incitement should be interpreted, a 6-part test based on the global standard. So to aid police officials, prosecutors, to have a very rigorous and robust approach to defining incitement, what is included and what is not. So there, because criminal law is involved, definitions are important. So the answer is not to have a more precise definition for harmful speech, is to ensure that we don't associate criminal law with harmful speech, but only associate criminal law with a very specific subset of harmful speech. For everything else, there are all kinds of remedies. Counter speech is one remedy. You have harmful speech that doesn't fall or doesn't meet the threshold of incitement. You might want to have counter messaging, where you resist that harmful speech with more speech. You might want to look at non-criminal law responses like civil damages. You might want to look at regulatory mechanisms, where if it's a broadcast of some kind, you might have a licensing regime that ensures that you don't produce and promote or disseminate harmful content. So there, having a more fluid definition for harmful speech is all right, because the consequences are not as severe as going to jail. right? So I think that's a better way of approaching these definitional challenges than always seeking precise definitions, because that, as you well know, terminology, language, all of these things are subject to evolution, and you can't ever get society to agree on what constitutes harm because it's such a subjective thing.
So I guess the fact of the matter is that to steel man the issue, right? So if you're a parent watching, for example, they may say, the online safety bill can be a positive because I'm not aware of what my children are doing online. They may be, led down the wrong path. Does the online safety bill have anything to do with any of that? I mean, is there some sort of steel manning where you can actually say, okay, there is some purpose to this? Is there something that you would like to, I think, maybe there is, maybe there isn't? What do you think?
So I think if we were to say that the online safety bill is a good thing when it comes to the protection of children, protection of women, because that was one of the arguments that was
child
floating
pornography,
around, right? A lot of the current law does that job, and if the real purpose of legal reform was to strengthen that that regime, that could have been done. Then you look at the current penal code provisions, you look at the current framework to protect children from abuse and exploitation, you focus on that and improve it. To have this massive legal regime, of which you might have 2% dedicated to this issue, and then say this is all about that issue, is a completely insincere. Because the online safety bill might have one specific provision that deals with this. That doesn't make the entirety of the bill palatable. If you are concerned about women and children, which is a great thing to be concerned about, look at the legal regime and strengthen it. And again, listen to the voices that have been working on this for many years. Because many of those voices are not asking for legal reform. They're asking for institutional reform. They're asking for the ability for a woman to go into a police station today and make a complaint about sexual harassment without feeling fear and without feeling like there could be a reprisal or being taken seriously. These are institutional reform issues, not legal reform issues. So I think it's an insincere thing to do to promote women and children being safer as the main purpose behind the bill, when the bill has 98% of other things that have nothing to do with women and children.
In your personal experience, Dr. Gehan, there seems to be an education gap because, I mean, even us, I grew up in a period time before the internet, right? So in the past, you would go to, let's say, a comment section below a post and then see what everyone's saying, just kind of ascertain whether this is true, whether there's some, whether it's completely false, etc. So is there, like, for example, I don't know if the national curriculum has anything to do with civics and ethics, for instance, but should there not be something in the education system where we bring on sort of skills to children about how to go through something online, what to, how to figure out what's right and what's not? I mean, for example, Twitter has community rules, right? So is there something that we should be proposing through our education system as well? Because there's surely some incentive on the side of the system and on the side of the user to protect themselves with better information. So how would you advise on that?
So digital literacy is, I think, a great alternative. Not that it will solve the problem overnight, but a great alternative to a criminal law response, right? So if the government today was to say, look, there is a problem in the online spaces when it comes to children being exposed to content that is harmful, and we want to launch this digital literacy program. And we want to involve necessary expertise, people who have worked on this issue for many, many years, who are not necessarily in government, but in civil society, in the NGO space. We want to involve them and we want to get their expertise as well. We want to have independent institutions guiding us as well. And we're going to launch this program and we're going to deal with this issue because we want to actually make our online spaces safer for children. I mean, I'll be the first to support that. I think that's a great alternative to having a criminal law response. Because the moment you have a criminal law response, you're at the mercy of institutions that in the past have not shown enough rigor in terms of applying elements of offenses in a good faith manner. Right? So then you run into the same risk of a new law being used in a way that is not, in keeping with the words of that particular provision or in keeping with the purpose behind the law, right? And that's what has happened with the ICCPR Act, and that was the concern that the Human Rights Commission expressed the moment the Online Safety Bill was gazetted, right? We didn't just engage with the provisions of the law. The prefacing sort of content, the paragraphs, was that don't go ahead with this at all, even if you have a perfect law, even if it's modeled on the best international standards, because you have an institutional problem that requires attention. Deal with that problem, improve your institutions, build public trust in your institutions, and then we can talk about new laws.
Right. Again, going back to the Learn Asia report, it talks about the Singapore Act. So it says that under the Singapore Act, a false statement of fact is defined as a statement that is false, quote, false or misleading wholly or in part, and which a reasonable person would consider to be a representation of fact. Now, under the Sri Lankan bills, the false statement is defined as a statement that is known or believed by its maker to be incorrect or untrue, and is made especially with intent to deceive or mislead, but does not include a caution, an opinion, or imputation made in good faith, or known or believed by its maker to be incorrect. So Learn Asia believes that this is a subjective criterion, and it's not clear how this will be interpreted. Could you?
That's a great question, and in fact, I was thinking about this the other day, that the actual threshold for determining that something is a false statement is a subjective threshold. You have to actually figure out whether the individual either knew or believed something that is false to be false before they made the statement.
This is like the crowded theater, screaming fire in a crowded theater in the US, the Supreme Court.
You have to know that there is no fire.
Right.
Because in the Singapore model, it doesn't matter whether you know or believe, it's whether a reasonable person thinks it's false, right? So here we've moved to a subjective criteria, which I think makes the enforcement of the law very difficult if it was to be enforced in good faith. That's the caveat, right? If we are really concerned about the text of the law, then very few people will be prosecuted under this law, because you're going to have to find out whether the person actually knew or believed that the person, that the statement was false at the time. You have to get into the minds of the person, and that's an evidentiary issue. Now, that's only if we're serious about implementing the words of the law. And I'm sure every lawyer who represents every person who is suspected under this this law will be, sinking their teeth into this definition, because it makes the prosecution of any individual, I would say, very, very difficult. But the problem with the infrastructure that has been created under the law is that the Online Safety Commission can issue notices, can obtain conditional orders from a magistrate, all without any interaction with the person concerned. That creates a huge problem, right? Because you can only make a false statement if you know or believe that the statement is false. I, as the commission, can issue you a notice prohibiting you from that false statement, or even get a conditional order where you have to comply with my notice without ever interacting with you. Now, how does that work? So that's why many experts have looked at this law and said this is unworkable. So I mean, in a way, you could look at it as a positive as well, because if the threshold is so high, not many people need to worry about this law, because all they really need to do is say, we thought this was true at the time, or we issued a disclaimer that we're joking, or we're not serious, and immediately you get excluded from the scope of the law. Because if you look at all the offences in the law, all of them, I think, apart from cheating by personation, it has the criteria or criterion of false statement within the elements of the offence.
Right.
So everything flows from the definition of false statement. So the fact that you picked on that is really important, because it's a very subjective definition.
I suppose the final question, Mag, the final point would be about the society that we are part of. And I don't think anyone can necessarily say they're a free speech absolutist. I don't know, maybe I might consider myself close to it, where I think generally words are words, actions are separate. So I mean, I'm of the view personally that you should be able to say whatever you want, and the person you're saying it to can say whatever they want in return, right? So that's a certain type of society that may be quite far removed from the society that we have in Sri Lanka. But is this sort of the fear that we have in our country, where maybe our leaders and the elders in society are quite worried about where we are headed in terms of, for example, with Natasha Edrisuri. Now, the joke that Natasha Edrisuri made was a very slight of hand joke. It wasn't something that was so insightful, insulting to the religion. But yet and this is not online, but she was still put in jail for a significant amount of time for making a very basic sort of joke. So does this online safety bill, in the context of the society we find ourselves in, what happened to Arnav Jazim, executive, for writing a book of poetry, what does this say about the overall climate of expression in Sri Lanka? And is this the trajectory that we should be worried about more than perhaps? I mean, I know that there are things in the OSB that are specifically harmful and things we should worry about, but the overall trajectory is probably even more important, is it not?
Yeah, I think that's a great point to end with, because the danger of any kind of law, any kind of new law on speech in this country is not so much linked to the precise text of the law. Yes, we have to look at the text, and the text can be dangerous, the text can be overbroad, but the text can also be perfect. The text can be absolutely on par with the best practice around the world, or best standard around the world, and still be a danger. And I think the danger lies in the selective application of the law against individuals that a powerful actor may not like. And you do that, or threaten to do that, a couple of times, you create an enormous impact on the space out there in terms of free expression. You have a chilling effect. And I think the real danger, not just in the online safety law, but any kind of law, is the impression created in the average user, average speaker, that, now there's a new law that I have to be careful about. And I don't really understand this new law because it's so complicated. So I need to be careful now. And the criticism or valid, legitimate concern I might have expressed in the online space yesterday, let me not do that today because I have to be careful now. And that can be a viral type of fear that spreads throughout a society. And people are suddenly not willing to speak out. And our democracy is ultimately hinged on ordinary citizens not only speaking out, but feeling the freedom and ability that to speak out, and to know that they have a right and ability to do so. Right. Without that, you really can't hold institutional actors or political actors to account. And then the democracy starts to decay. So I think that is the bigger risk of any new law that is brought in. The complications or the sophistication of the law put aside, if people have a particular impression, people might hesitate to speak out, hesitate to express themselves. And then we have a much more serious problem.
Well, Dr. Gehan, thank you very much once again for being on Insight with us and explaining the online safety bill. So as we said, it's all about the trajectory of our society and what kind of society we want to be in going forward. Thank you very much for being with us on Insight, and we hope to see you again soon.